Now, I'm sitting at challenge for Victoria, sitting by a laptop computer over there, and never read this. I did some of this not long ago, my data around all that. And she actually didn't do a good job trying to chase me, so if the slide doesn't match what to say on that experience. And so what we're starting with, I wasn't asked. She's enormous and so much help. So what a recent case is shaping future family trust dealings. The first of these cases that I'm going to talk about is began as Bendel against the Commissioner of Taxation. Bendel was successful in the Administrative Appeals Tribunal. The Commissioner of Taxation didn't like that and appealed to the Federal Court of Australia. I think the surprise, the Federal Court of Australia unanimously held that his argument, the arguments were being put on correct. Generously, the High Court of Australia has given leave to the Commissioner to appeal, which is unusual in tax cases, because the High Court by and large is the determination of tax issues sits with the full Federal Court. It's been part heard. Again, the Commissioner, as I understand a report from the Australian, I haven't seen anything higher than that. And again, was surprised to find that the court was interested in delving into arguments that the Commissioner was making. So it's been adjourned, Commissioner, to make a further written submission and tentatively to be reheard on the 3rd of December. So there's great professional interest in this case. Not exactly sure why. Certainly it's interesting for legal professionals from the point of view of statutory interpretation and what the courts, well, the different approaches between the tribunal court and what will emerge to the full court and what will emerge from the High Court. So we're all very interested in hearing what the High Court has to say, but what's the relevance of it? This area is pretty simple. A discretionary trust of Mr. Bendel had accumulated and annually sent money, made, sorry, not sent money, that's quite wrong, made companies presently entitled to receive money from the discretionary trust, but he didn't pay it. So that's why I sent money from. And so the company had what is called a unpaid entitlement, in the jargon of the tax profession, a UPE. So there was this UPE sitting there. The company and trustee might have entered into a loan agreement under which money was lent back by the company to the discretionary trust, and pending the circumstances being agitated. What was Bendel doing? Well, doing what a heck of a lot of people do, seeking arbitrage between the 30% company tax rate and the 47% individual personal tax rate that he would be paying on distribution, on individual distributions of that income from the trust or as a dividend, which would be, he would have wanted to frank out for himself those trade company tax. So anyway, that's the scenario. The Commissioner has an anti-avoidance provision, provision 7A, which in the, we've got two income tax assessment acts, one from 1936, which is provisions of which when you're on, and one in 1997, which was an attempt to rewrite the whole lot, but got stuck it's the way through. So anyway, this is back in the 36 Act. And so the this provision 7A says, well, if a company has a UPE, a trust, and it pays an amount to a shareholder or an associate of the shareholder, that's a dividend, or deemed to be, if it, or the trust, or this angle on that, if the trust pays out, then that's going to be deemed to be a dividend. Or if the money's lent, which is where we are with this deposit there, so if the money's lent to a shareholder or an associate of the shareholder, then that can be deemed to be a dividend. Or if there's a debt that's owing, that's forgiven. So, and this can happen even if it happens through directly or through some what we're facing with beneficiaries is a slightly curious position in my mind, because, and I think in the Administrative Appeals Tribunal's mind as well, because the Commissioner seems to have had an avenue to attack by saying, well, you've got access to money out of the trust, and therefore able sit here, down here. This subdivision EA will apply to you, and you'll be deemed to have had a dividend. But the Commissioner didn't do that. The Commissioner said, no, I'm taxing you on the basis that your UPE is deemed to be a loan by the provisions of Division 7A, notably a section 109D. So, and why a loan? Well, because 109D subsection 3 has an extended definition of what is a loan. Talk about it. So, so that was challenge, and as I said, I think the tribunal sort of said, well, hold on, you had an avenue to tax this person. If you're trying to tax him this way, aren't you going to end up with double tax? And you get introduced this subdivision EA for the very reason that there ought to be a loophole of the kind that you're now saying doesn't exist. And you need a statutory remedy for it. So anyway, we have what we have with the Bentall litigation. If we look at the I've got a wording on with that somewhere that you know. So we've got a chronology of it, as you'll see. So it's got from 22, the ATO, 23, the 22 assessment, 23, the Administrative Appeals Tribunal. A couple of fellows that I know well. I think, Michael, you probably know Keith James at least. I know about Frank. And then on to the full federal court, to quite a different team. Not including Justice Logan, actually, at least. So, given the judgment, the first round of the Commissioner is judgment highlighted. And then when the full federal court came out adversely, the national tax profession said, well, now Commissioner, you need to administer the law in accordance with what's been declared by the court. But the Commissioner said, no, here's my interim decision impact statement that says I'm not doing anything of the kind. I'm going to stick with what I've said is the position I have said, going back to my tax determination back in 2022. So that situation's creates some tension for practicing registered tax agents, because if the court endorses, if the High Court endorses federal court, then and in the meantime, registered tax agents have been advising their clients the better course of action or correct course of action is to enter into a loan agreement. They may be found to have not have been giving advice correct by the law. But if it turns into the other way, well, they'll take it to safe courts, and then what the taxpayer's not going to be penalised. So I think that's part of the tension that this is creating, why it's creating the interest that it has. As you can see, as I've mentioned, this timing, the High Court, now I know why I'm different here because of double-sided. Yeah, so the High Court's heard it, going to press on. If you just go back to further taxing and relief points, yeah, the Provision 7A contains within it, and I've already mentioned about the loan agreements, contains within it some relief provisions that say, well, if you have a UPE, if you like, you have the opportunity to enter into a loan agreement, either one, there are a variety of ways to get there, but 7, 10 or 25 years, depending on whether you give security, that requires the repayment of the UPE as a loan, now documented as such, but you be paying benchmark rate of interest, which is present in this 24-25 period, 8.77%. Or if it's what's called an amalgamated loan, which means it's more like an account that where people come and go and borrow their company over a period of time and strike a balance due. If you're in that situation, then you need to have within the loan still paying benchmark rate of interest, but there's a formulated structure for paying minimum yearly repayments. And they will amortise the debit balance as it stands at the 30th of June. And that's all well and good if you're, as I said earlier, arbitraging the difference in rates and then you're able to deduct the interest. But not quite so bad if, not quite so good if you can't. And of course, there's still an obligation to repay. And a lot of these situations, taxpayers might have to pay either too. So what are we paying only the corporate rate and then being able to find the money somehow and not have to repay it. Ideally, not for a very long time. And Mr. Bendel seems to have something like that because his UPE was $1.4 million in debt. So with tax and penalties and interest, quite a lot of money if he loses. So that's good. So this is the section I was talking about, 109D, and this is imputing a loan. It's providing for where you make a loan, the loan's not fully repaid, and then the loan is defined to be an advance of money, provision of credit, or any other form of financial accommodation, payment of amount or unaccountable behalf of a requested entity if there is an express or implied obligation to repay the amount, and a transaction which in substance affects a loan. So that on its face seems pretty wide-ranging provision, and as I've said, the Commissioner, tax determination back in 2022 said effectively that, as far as the Commissioner was concerned, a UPE was covered by those provisions and deemed to be a loan, and consequently a tax liability arose unless one of the safe harbour provisions was accessed. That's probably, it's probably all you can read, but I will keep going on that. And that position was provided to the UPEs going back 16 December 2000. The Commissioner issued another, what's called PSLA, which is a administration guidance document. They were withdrawn, but then they're still being administered for anything from before 1 July 2022, but these rulings came into effect after that time. I say here the tax determination also addresses sub-trust arrangements, so the Commissioner allowed there not to be a loan if the trustee declared that the UPE amount was held on a separate trust for a particular beneficiary in whom it had been vested. So that sub-trust arrangement was another form of safe harbour. Interestingly, at the State Convention of the South Australian Division of the Tax Institute a few months ago, when there were about 100 the audience was asked if they practicing tax lawyers, continually about the sub-trust arrangement, and the answer, no one. So hence I'll leave aside sub-trust for the moment. So I don't think I need to dwell much. The Bendel facts fitted the scenario. There was a private company that distributed money to family trust distributed money to a private company, and it is only applicable to business made to a private company. And they've racked up that level 1.4 million. Just to attack the on the basis that these loans. As I said, the tribunal actually went into quite a considerable amount of an analysis, hinging not so much on wording within 109D, about what's allowed and what's not, but more about, well, how can this work? You don't even have double tax if you tax. You raise taxes at this point with them as the amount of the dividend into the trust income. It's going to be taxed there. And then when it goes out to beneficiaries, it's going to be taxed again. And the provision that normally relieves against double taxation potentially doesn't apply. And didn't you bring in subdivision EA or 7A entirely for this sort of situation? So you're trying to do you've got double tax or triple tax, or in the end we've decided no tax the way you're trying to do it. So then the substantive pensioner then took Mr. Lendell to the full court, federal court, and the full court actually uncovered, but he said that the tribunal hadn't actually engaged itself in the correct inquiry, which was to look to the text of the statute, particularly the text of 109D3 in its deeming of what makes a loan or not, and proceeded to make fairly sharp analysis of that provision, and saying, well, now look, the essence of a loan is that you lend some money to someone, a borrower, and you have terms which might be a little bit of being paid for, but the essential term in their mind was this obligation to repay it. So nothing they could see within the wording of 109D3 contained this essential element of an obligation to repay. So, sorry, I don't know if we can go back to where 109D was. Yeah. Next. There you go. So you can see, like, the loan includes an advance fee. Well, there's an advance, but to the caller, that's only half the story. Where's the obligation to repay? Provision of credit or any other form of financial accommodation. Well, again, okay, there's half the story, but where's the obligation to repay? And just interestingly, the High Court's apparently take significant interest in the phrase financial accommodation, which does bother in a variety of circumstances, not just in tax act. Corporations Act, for example, regulation statutes. So there's half the story, a payment of an amount on account of, etc. If there is an express or implied obligation to repay, so the court says, there, see, that's actually indicating the relevance of the need for this obligation and a transaction which in substance affects a loan of money. So that's there's nothing catch-all that means basically that the parliamentary council like falling upon. So so that's where the federal court, the foregoing the federal court meets. And as to incidental arguments about why is it under EA, I think they said, well, we don't need to, we wonder, but we don't need to answer. And as to the double taxing provision, well, needing to be interested in that either. That has been argued in quite a lot. So as I've said, you could wind back up. As I've said, the Commissioner's response to the full court's decision was to say, well, we're not changing our practice. To hell with the tribunal and the full court and the federal court. I'm a member of the Law Council of Australia's National Taxation Committee. So some of our members got upset about the Commissioner not following the laws that have been declared by the court, and engaged in a exchange with correspondence with the Commissioner. The Commissioner remained unmoved. Curiously enough, the Commissioner has said in the scenario that I showed that if the UPE is applied to working capital within the trust that's made a contribution, then all is well and good. So they won't exercise powers to agitate any argument under Division 7A, but needs to be put under a loan agreement. So it's giving away boomerang in a way. But nevertheless, and yet, as I was saying, well, it's not harmful really in those circumstances because there would be deduction and accessibility which match each other for the interest that might be paid. In seeking special leave, the Commissioner managed to convince the court to give, as I said, the High Court. The Commissioner really pressed the same arguments that had gone before. Just Division 7A was intended to be introduced to remedy an anti-avoidance provision to prevent people accessing money in a company in circumstances where definition of dividend, which is in a different section, section 44 of the 1936 Act, didn't apply. So these were, to use the phraseology that the bench would disguise dividends. So the Commissioner's argument went, well, so this is a remedial anti-avoidance provision that ought to be interpreted expansively. I suppose we'd say, what do you mean, not according to its words? So, of course, it involves counsel through attention to subdivision EA, supported the tribunal's ruling on decision on that sort of basis. Wasn't to extend to Europeans. So there was argument in the court around the section 6-25 double taxing provision. And the Commissioner wants to say that there has to be an exact match between the reason that you're taxed in one way and the reason for tax in another way, and without that exact match, double taxing provision doesn't apply. And so the Commissioner argued, well, what vendor was being taxed for as being deemed to be a loan was different to what vendor would be taxed to be for on a distribution of. So, sorry, might be double tax according to the pub test, but no, the statute of accommodate. But on the other hand, you read 109 expansively to catch the double tax under its provisions. I kind of mentioned already that the High Courts have heard the matter. The report of the Australian, which is it's quite interesting. It says that the aforementioned High Court, which represents the judges, including a couple, Justices Stewart Gordon, who both practiced in the tax field, which has been rare during their careers, particularly as counsel. They agitated the Commissioner's Counsel quite a lot. The Commissioner's Counsel apparently got somewhat perplexed this evident position the Commissioner was putting wasn't being evident to the court. And as I've said, so they seem to, according to the reporter, quite misjudged the appetite of the court to engage with the matter from its roots upwards, and so that's having made further submissions, and you'll see what comes of that later. I have put just a quick slide here. If the High Court upholds full federal court, is seem to have something of an appetite to do so far. What there's been a lot of newspaper talk about large amounts of money being likely to have to be refunded to taxpayers. Curiously enough, that's a I talked about there would seem to be almost unanimous agreement that the best thing to do is advise clients to put their UPEs on loan agreements and play safe. So, so if that's been the case, well then the Commission hasn't got anything to worry about, or the Treasury doesn't have anything much to worry about. But interstate people might be a bit more adventurous than here. But the Commissioner has said in the interim division impact statement, decision impact statement, that even if I can't get you with Division 7A, I've got other anti-avoidance provisions that I can access, and talk particularly about that section of 100A, which is a ghost from the past, trustee, which was anti-trustee, but is so widely written that Commissioners now logged on it many years later to say, well, I can get you under this because that provision, assessment under that provision has no time. So whereas normally to issue a recommended assessment to someone, there would be a just situation of 4 years time limit from the date of the assessment. which becomes a due and grant day. There's no such time limit. Not sure that there's all the money that they've asked and hold to this, but there's definitely lots of interest. And that interest might have extended to about the 2024 year, because there's tiny provision for entering into agreements relating to amalgamated loans, or either way, the time limits. Either you've got to do an agreement by the end of the tax year, or you have to have done it by what's called the lodgement day, which is the earlier of the day you actually lodge, or the day you are required to lodge tax return. But for some, 30 June 25 might still be alive. It would have been nice to have heard from the High Court before lodgement day, but that possibly is not going to happen. So maybe the person who's got most of this may not be the Treasury, it just may be Mr. Bendel. 1.4 million plus staying. So enough of that case, let's talk about something else. I mentioned a case where the court was approached about vesting, changing a vesting day for a trust. Now, this is interesting because we are seeing trustees that were created in the 1970s, copied out of trustees that were precedents from interstate. We have legislation working up in New South Wales generally at a stipulated time period. It might have been 50 years, might have been 60 years, might have been 80 years. But as to those that have had time limits of 50, and we are seeing, and they are coming up towards the end of their time. And no one wants that. These people want these to last with them so longer than just, if you like, one generation. And we're certainly seeing them entering the third generation with all the problems that's creating. Story for another day. I mean, I look at my own family trust from way back that time and got a bit surprised to see that if Lady Helen Taylor, daughter of the Duke of Kent, was happened to die, I only had 21 years left. But her father made it to 90 and her mum died at 92, so we've got a chance to be for a while, yes. So, but one of the, this is a bit of a nasty, it was very common in limiting the life of trust. And why would my trust be limited? Well, because at the time there was the rule against perpetuities was law, and that said that on settling a trust couldn't have a life longer than a life being plus 21 years. So universally, a royal life was chosen because at least you kind of knew when they died. But at least you knew, supposedly, when those people died, you could mark off your 21 years. South Australia has now abolished the rule against perpetuities. Thank you. But one of the common provisions of trustees against perpetuities in mind was to also forbid distributions from the trust, that I call it the distributing trust, to a recipient trust that whose perpetuity period was longer than that of the distributing trust. And it's quite common, particularly in real estate environment, for trusts to be formed later because you might have a profitable distributing trust and you might have gone out and negatively geared the property new trust, not telling the land tax commissioner that that was in order to avoid aggregation, but it's still borrowed in your distributing trust. And so you've got a flow over, and there's every chance that the family might have appropriated was when you did the previous trust and the new trust, therefore you would have that recipient trust ineligible to receive a distributing trust. And so the Commissioner is alive to this, and I'm aware of one case that's been going for a few years now where the Commissioner is not talking on settlement. He was wanting to push the issue. So in South Australia, get rid of those things. Probably the sooner the better. The only thing is that, and what I'm urging you to hear is that most trustees have provisions that say, well, in default of the trustee validly exercising the question, their pressure to make distributions to beneficiaries, if they don't do that effectively, then the distributions will default to named persons. It's well and good, but some of those persons might be dead if you're talking about trusts that's that old. But anyway, so that in itself it's not a good situation because people can be taxed if they didn't get any money. People can argue about that they were entitled to money and why didn't they get it. And they can say, well, I don't think you can follow this works, I'm taxing the trustee at the maximum marginal rate of tax as the accumulation of the Section 99A. And I've got unlimited time in which to do that because the trustees come out of previous assessment. So that's really a good situation. The other thing is that the trustee then needs power to make the amendment to introduce or to get rid of in South Australia these restrictions. Some say to interstate people are saying, well, can we amend the trust to make the law of South Australia the law of the trust? Yes, you can, but that won't necessarily be effective if you own property in the state because the law of the state where you own the property will apply to that holding. So if you want to create, for example, here's a clever idea, I can't dispose of the property, but I can create an option now for someone to acquire it. So that'll mark off the value at this time, they can pay market value on a future gain, will belong to the option holder for an indefinite period. Answer no, because the restrictions on creating interest for any period beyond all against perpetuities or the statutory years will still be fine. So, so anyway, not only do we need power, but for a long time, the Commission of Taxation took the view in issuing a very contentious document called Creation of a New Trust Statement of Principles. You didn't have anything to do with the authoring of that, Michael. That a change to the trustee of what was called the substratum of the trust. So the substratum was seen to be the essential terms, and one of the essential terms in the Commissioner's side was the period for which the trust had been created. Change that, and the Commissioner would take the view, was threatening to take the view that the CGT event had happened because you created a new trust. So, as you see, that matter was taken with the federal law. Just interested in that case, Clark's case, which then led to the Commissioner withdrawing response and issuing a new tax ruling, which was with a 180-degree turn around, saying, well, if your power amendment authorises it, well, I'm not here to argue with you. So go ahead. And in lots of other ways besides just changing the date, obviously. And of course, and I mentioned there the superannuation funds. That's basically from these laws situation and said effectively, who's come and go by the old superannuation fund. But if there's a continuum of administration, property, and trust, kind of continuation of a designated superannuation fund, there's not a CGT event happening to the fund. So, talking about amendment is some war stories, because partly because trustees have become commodified, and commodity providers seem to make all sorts of embellishments to what's said, and in the process of doing so, putting words that is correct to what's intended. So, examples that I have here, like in this County case, the Western Australian Court was faced with two trustees. I keep going on by members of the family that have managed to get hold of control of the trusts, but and to make changes that were adverse to other members of the family. The courts looked at the trustees carefully and said, well, hold on. Here I'm looking at this trustee, and it talks about a power amendment of the trusts, but you're amending a schedule, and that schedule is not the trusts. So I'm sorry, the amendment you're trying to make isn't within the scope of that. And then in other circumstances, like you can amend trust hearing before declared, so that under power amendment. So at that point, it's only applicable to the hearing before, not hereafter. So there have been quite acute points taken, mainly in cases where there's been a bit of mischief going on. People interested in trying to stamp it out as best they can, because the trustee having an absolute and uncontrolled discretion which is the phraseology that is in discretionary trust, both in the big capital, is an enormous wild card. So another little issue is lots of these trustees of old talk about being able to be amended but require the consent of the appointer. Consent of the box either they can't be found or worse, we don't have alive. So that's a difficult problem because you have to end the power of amendment to get rid of the restriction on the power of amendment. It's possible to apply the Supreme Court. The Trustee Act, Section 59C, contains power for the court to order amendments. There's a case I'm going to talk about, but I'm not going to talk about it in any great length of time. It's the family trust, where the trust was a 50-year trust, and it would, at its time of death, and so the trustee made an application with the support of all the adult beneficiaries to extend the period from 50 to 80 years. There was just had a power of like $80 million worth of real estate was producing getting about 700,000 a year. And one of the significant grounds was that they're going to walk into a $10 million liability. So the Victorian Court went through it all, went forensically proceeded on a form of analysis that it's perhaps in some ways a little bit different to what's in, because 59C of our Trustee Act prescribes what needs to be done before our court, or considered by our court. But what was interesting was the reliance on CGT, whereas 59C specifically provides that our court can't be, it requires our court to be satisfied that the application for amendment is not substantially motivated by a desire to avoid or reduce the incidence of tax. So I don't think Reed or Smith Family Trust would have enjoyed the same success before our enjoyed. But it's an interesting case if you're forced to try. And part of the reason was, well, this was favoured by the adults, and there were infant beneficiaries, potential beneficiaries, and there were potentially unborn beneficiaries to come. And this was a family trust, and the so there might be other ways. The tax commission takes the view that any attempt to change the vesting date after it's occurred, it's too late. But again, Victorian Court, in the case that I put them again in anti-trust, has said, no, that's right. This trust was being run way past its vesting day, or well past its vesting day. Everyone was happy. It was running. The trustee was administering it for the beneficiaries who were receiving distributions, and they were happy with money. And so we think that's all fine. Just extend the time, notwithstanding that it had expired. One of this is that if being a trustee, any good corporate trustee, well, whoever the trustee is, particularly where you're a corporate trustee, you need to make sure that you not only comply with this, but have the power to exercise good with the way the trustee requires, but also that you observe the institution of the corporate trustee. We had a case recently where the widow of the deceased husband continued in fact in trying to the family account to try and continue to exercise the powers of the corporate trustee as a director. Only to find that the Constitution required for for the valid directors meeting that there be a quorum, and the quorum was 2, and probably addressed by a guys who can't count the other directors. That needed next resolution for the appointment, either to fill up the vacancy or to make a further appointment. So that appointment was invalid on the decisions of the board. Unfortunately, that was the case. The tax commission with struggling potential beneficiaries. We thought they would be getting more than was getting. It was giving pretty much everything to herself. So again, there's, if you face that sort of situation, there are provisions in Section 100.332 for the Corporations Act that might allow an application to the court to get that to overcome. I've also thought about lots of trustees. So, in the case, I don't think in here, the essence of the case was that all the evidence of the trustee was contained in a mortgage to the National Straits Bank, which said that the mortgage was the company in its capacity as trustee on family. And the date of the trustee in 1 April 1982 is settled in the real Margaret Hayes, who happened to be the PA for Mr. Sorry, Mr. Philip, I think. And they didn't know anything else more about the trust than that. The trust had filed financial statements. So that seemed the fair recognition that the courts had made. Without a trustee, issues are so essential for trust is certainty of objects. We can't be certain about who the objects are. So we find that there is a resulting trust in favour of the settlor. Settlor isn't nice. We think she was just fronted up by Mr. Allen to create the trust. We think he's the real settlor, so everything can go to his deceased estate. But no, vested in, which is vested in his late wife's deceased estate, which will eventually get it to his children. So, I think I've run out of time. There's a key. This next case is really tricky, but just this right of indemnity. this case went to the High Court. What happened, in a nutshell, guys, me for a couple of minutes, was that the trust had a debt, a liability to a creditor, appointed a new trustee, transferred property to the trustee. That's well and good because the creditor had an ability through subrogation of trustees' right of indemnity against property to claim on the property when it went to the next trustee's hands. But that trustee then deliberately, fraudulently, transferred the property out to beneficiaries. And the High Court said, sorry, creditor, you've got no right of action against these people to enforce that right, the trustee's right of indemnity, not subrogation. Equity, you're making a claim in equity. Equity doesn't act in what's called equity. If it's property credit, it's like bridge, it only acts what's called persona, this Latin system. And so you can go sue that person, you can sue that trustee. That's got nothing, of course, because the property's gone, but you've got no remedy against these. Sounds like a good idea if you want to think creditor, but don't do it to the tax commissioner because you've probably got taxation offences there. Bring it all along you. So you have to come back next time to hear about each investments. It's a standard house in Australia. It's development, very interesting. In the end, I think it just turned on my former partner, Campbell Rennick, it's exciting for something he thought to perform for the which I'm a big fan. Product additional interest, which we all hate and see never to have been introduced to give territorial protection, but now things all things to every provision where it's mentioned in the standard is name. So that was a bit of a sad day. And case by motor, which I went to. This is really just a crazy case. All right, so anyone wants to ask a question, you're welcome.
Just briefly, Vandal, appreciate it, please. Vandal. So we have a distribution out of a trust for the company, that's assessable income for the company. But the distribution is not paid, that's why it's called an unpaid revenue type.
Yeah.
And the commissioner says, yeah, well, that actually represents a loan from the company back to the trust. Away, and it's a loan, then it's a loan to an associate, presumably, which means it's a dividend, then dividends. Yeah, the commission or the full court said, yeah, it's not a loan because it's not a prepayment. Make up, I get that. Did Bendel have a Deep 7A loan agreement in place to cover that off, or is that the question?
Not. That's why he didn't have.
No. But if he did, then that would recognise the existence of a debt, which then have to be repaid by
Yeah, it's got up. Yes, terms.
Yeah. So the problem for him is that there was no loan agreement in place.
Yeah.
He just relied upon the fact that it wasn't a debt.
Yeah, and if this case gets up and successful outruns the tax rates, because I had 30 cents a dollar. But if the commissioner gets up, he gets taxed with no franking credit. So
it's also
yeah. Something is good, I think
Yeah, but the commissioner then say, yeah, well, because you're looking for that arbitrage, I'm going to smash him up under Part 4A anti-avoidance. That's why you're doing it.
well, the commissioner argues that on top of any specific anti-avoidance provision like it was today, he can rely on Part 4A as also. Of course, actually, double up.
Yeah.
Way. It's probably been no less. Probably by a possibility, but in those situations, would say, well, did the examiner exist to effectively reduce the consent to the examiner, but unsuccessfully? Right. Leaving you being there, say, but they have to pull one of them because you don't have to. Why would that turn around and for a dominant bullet purpose extension like this? Yeah, I mean, I'm only a bit naive a bit. How far apart will they get there? It does turn on that. And it's upstairs. And the criteria by which you measure the time.
Jonathan, monitoring giving exists, it would have to be the 1% interest rate for.
Well, it would be at the benchmark interest rate at the time it was entered into, but the formula for an amalgamated loan works the formula year by year by year according to whatever the benchmark interest rate's been for the last 12 months. So on an interest rate cycle, but you don't have to repay them. You don't have to get money. And you know, he says you can't. Why? So why give the commissioner a back door go? Oh, that's interesting. All right. Yeah. Okay.